The first step is to articulate what you're talking about when you talk about legal risk. In the last video cast, we talked about the interaction between business operations and the law. The next step in terms of identifying legal risk is to add another level of detail to those interactions to create what is essentially a mutually exclusive and collectively exhaustive categorization of legal risk. At a high level, Chris and I talk about legislative regulatory risk, so the way the law and regulation that applies to your business. We talk about contractual risk, so the contracts that you enter into, the obligations that they impose on you and the rights and enforcing the rights that you have within those contracts. Non-contractual rights, essentially IP, so ensuring that you are enforcing your non-contractual rights and that you're not impinging on non-contractual rights of others, of course. Non-contractual obligations, which is a slippery category because what that speaks to is the spirit of the law rather than the letter. And it's really a way of trying to stay ahead, particularly in regulated markets, of where regulators are trying to get to in terms of their interpretation of the law and the likely sanctions they'll impose if they feel that you're breaking the spirit of law or regulation rather than the letter. And the final category is dispute risk. So not so much avoiding disputes that you may be subject to, but the way that you manage those disputes as a method of reducing the potential quantum of loss. So how to identify legal risk, 5 clear categories, and assess the impact or assess the potential operations within your business within those 5 categories.